right. I'm trying to get a literary. Turns out
July 24th.
Oh, all right.
No.
All right. That's good.
Oh, you had me worried there.
just keep writing. I'm sure I'll get
And you just
I just
wow, maybe we're ready for
they did it great.
we're sharing the big mic here.
Usually fairly confident.
That's right.
No, I meant recent. No, we did a piece on retreat. No, I'm as young as I was.
Why the approach is not the one that.
We'll talk later.
Yeah.
Engage in commercial negotiations.
Yes. Oh, you did not have
So I have this inherent putting the company away.
Yeah.
I'm not quite sure what to do. 15. Oh man.
You're looking for sort of the.
I don't know that anybody said anything. I don't know that anybody said anything about what. I don't know that we're gonna reply or not. I mean, like, I don't know if anybody's engaged on particular issues.
And we've not set the box up. We wrote this picture. That was
How are you, my friend?
no, that was the cable.
Right. Well, I try to always, I try to not follow unless we got something to add.
Right. Yeah.
Like I can't stand the replies for like, look at all the people who agreed with me.
Right. Yeah.
So welcome everyone. Let me. Why don't we get underway here? Just a couple minutes late. When we set out to have an event on copyright and to do it in July, and it ended up working out that it would be in early July, the week of the 4th of July. We thought, well, we'll have a few folks over for lunch and see who shows up. And here we have a room full of folks, and I think that's an indication of how important these issues are in public policy and in the way we think about our approaches to the economy and to rights issues. So I want to welcome everyone here. My name is Jeff Eisenach. I'm the director of AEI's Center for Internet Communications and Technology Policy and a visiting scholar here at AEI. I don't consider myself an expert on all various aspects of copyright law, although I occasionally play one as a consultant, economic consultant, so that's almost as good as on TV. I am delighted, though, that we have some real experts on the topics we're going to talk about today here with us, and my role is going to be to serve as moderator. We've set this up as kind of a three-phase process here. We're going to spend about the first 25 or 30 minutes with an exchange of views among our four main presenters today. And then we're going to broaden out and ask for comments from folks who are sitting up here at the table who we've selected on the basis of their expertise and interest in the issues at hand. And before we're done, we're going to do our best to get to some questions and involvement from folks in the audience. When we do that, we'll ask you to grab a microphone and announce who you are. I will just not make substantive remarks, but just note that the copyright issue is one that I first came across, I think, in the mid-1990s when Congress was debating a little thing called the Digital Millennium Copyright Act. And I think it may have been Fritz Attaway and Sarah Deutsch who actually ended up coming to blows on a stage. For those of you who don't know, Fritz Attaway was at MPAA and Sarah Deutsch was at Verizon, and the question was how responsible Verizon ought to be for protecting MPAA's content on the internet, and they didn't actually see eye to eye to that on that issue very much. But the thing that impressed me was that it was an issue that really got people's dander up. So we're going to have a polite debate today, but we also understand this is an issue that brings out strong feelings, I think, both in terms of the magnitude of the economic interests at hand. And I'll just quote one statistic. According to a recent study by Ocean Tomo, which is a huge intellectual property, worldwide global intellectual property valuation firm, 80% of the market capitalization of the S&P 500 today is accounted for by various forms of intangible property. Kevin Hassett has done work on that topic also and come up with kind of similar results. So regardless of whether you believe the number or not, the truth of the matter is that what produces wealth in our society today is a lot more, is at least least as much knowledge as it is that old tangible stuff that we used to call the K in capital in economics class. So how we deal with that and address the issues that come up, economic issues that come up associated with that is our topic today. And we have four great presenters and speakers who are going to bring different perspectives to this. And I will say, our focus today, to some extent, is on how conservatives have approached this issue from different perspectives. Conservatives don't all, no matter what you might see on CNN or MSNBC, don't always see things exactly the same way. There is a variety of views on the conservative side, and you're going to see that. You're going to see that in evidence here today. So part of what we're trying to get at is for people who approach the issues of economic issues in general from a generally kind of free market perspective. Often you would expect them to come out on the same side on what seems like an economic policy issue or an issue of property rights, but sometimes not so much. So we're gonna see that in play out today, and I think it's going to be interesting as the debate goes forward to see the issues that we touch on. So who are our speakers? Again, I'm delighted to have all four of them here. First, Jerry Brito is a senior research fellow at the Mercatus Center at George Mason, serves as director of its technology policy program, and he is most recently the editor and one of the authors in Copyright Unbalanced: From Incentive to Excess, a book about copyright policy from a libertarian perspective, published by Mercatus in 2012. Jerry's going to be our first speaker. He'll be followed by Mark Schultz. We're going to have a George Mason to George Mason debate here to kick off. Mark is co-founder and co-director of academic programs at the Center for the Protection of Intellectual Property at George Mason University School of Law, and serves as an associate professor of law at Southern Illinois University. He's taught, written, and lectured extensively on copyright, trade secrets, and other issues, as well as having testified before Congress on the same issues. After Mark, we'll go to Tom Palmer, who is the executive vice president for international programs at the Atlas Economic Research Foundation, where he coordinated operating programs in 14 languages for a global network of think tanks. And he's threatening to make his remarks today in German, so hopefully everyone kennt a little Deutsch. And if not, we'll have it translated by Google in real time on the webcast. But Tom has written extensively on copyright issues and comes at it from a little bit of a skeptical perspective. And then finally, Stan Leibowitz, who is the Ashbel Smith professor and head of the University of Texas at Dallas's Center for the Analysis of Property Rights and Innovation. He is a leading expert on copyright issues for the last decade or so, and has been published on these issues in such journals as the Journal of Political Economy and the American Economic Review. So I don't think we could have a better set of speakers to lay these issues out for us. And Jerry, I'm going to turn the microphone over to you for about 5 minutes each in opening remarks.
Great. Well, thank you very much, Jeff, and thank you very much to AEI for having me here. I think you're absolutely right that this is an issue that really divides those on the free market side. And I think that's one of the reasons why I'm so excited to work in this area. It's an area that's never bereft of interesting debates to have, interesting angles. And I think one of the reasons why this area divides so many on the conservative, libertarian, free market side so much is because it's seen very often in moral terms, right? Are you for property or you're against property? I don't have particularly strong convictions, moral convictions, I should say, as far as copyright goes. I'm more pragmatic about copyright. I sort of take an economic way of thinking to copyright. To me, copyright is a tool that government uses to promote a public good. That public good being expressive works, right? Access to expressive works. And it's very simple. If we did not have copyright, we would still have songs, we would still have movies and poems. We probably would not have as many. And so, wanting more than what we would otherwise have, we employ copyright. We grant authors for limited times an exclusive right to their works, and that gets us a greater public good. All right, I'm being told I cannot be heard. Can you hear me now? So, looking at it from that perspective, immediately, as a free market person, I sort of have the same reaction I would have to other tools that government uses to promote a public good, right? So to me, copyright is a tool that's very similar to the tools the government uses in cap and trade, right? So these would be emissions permits or taxi cab medallions. It's the same sort of tool that government uses to accomplish to solve a market failure to create a public good. And as conservatives, as libertarians, as free market folks, we should apply the same critical thinking to copyright that we always apply to things like emissions permits, like taxi cab medallions. So we ask ourselves, first of all, well, how do we know that the government, when setting the boundaries of this property right that they're creating, this tool that they're using, that they're getting it right? Isn't there a knowledge problem here, what Hayek warned us about? That a central planner is always going to have a difficult time getting at exactly the right combination of institutional rules. The second thing is what Gordon Tullock taught us, which is from public choice, which is that when you have a government tool, you're going to have interests who are going to be sort of putting pressure to ask that those boundaries to be set in different ways that benefit them. So, when conservatives look at cap and trade, they're skeptical because, well, that cap can be set too high or it can be set too low. There can be too little or too much enforcement. And how do we know we're getting the right balance? And, who is making that decision, right? And I think we should approach copyright the same way. The first Copyright Act, which the framers legislated, right after they wrote the Constitution, they legislated the first Copyright Act. It was limited, copyright protection was limited to maps, charts, and books, which meant that other kinds of expressive works, such as music, plays, these were not protected. And the framers, they knew about these things. They were not unfamiliar with movies and plays and sculpture. They just thought they would get enough of these works without the subsidy. Were they wrong? Right? Today, songs and plays are protected, but fashion designs are not. Do we have the right balance now? And how do we know? Right? When the first Copyright Act was legislated, it was also set a term of 14 years, renewable for 14 more. And it required authors to register their works, required them to go and seek that protection before they would get it. Was 14 years enough? Was it too little? Right? Today, the term is life of the author plus 70. Right? Is that too much? Is that not enough? How do we know? Right? Should we require that somebody ask for the privilege rather than getting it, an automatic copyright? So I think I'm going to stop there. I hope we can get into things like retroactive term extension, which I hope, as conservatives, as libertarians, as free market folks, we can all agree we should never have again. So I'll stop there and hear Mark.
Yes, sir.
All right. Okay. So Jeff asked me to consider the compatibility of copyright with free markets. And so I'll consider copyright both in principle and briefly as applied. So first, in principle, if you like free markets, you should like copyright. Like other property rights in general, copyright supports liberty. So there are three ways in which property rights generally support liberty, and copyright scores well on all three counts. So first, property rights support independence. When people are able to own the fruits of their productive labor, they have the means to support themselves and thus live a truly free existence. If you can't be secure in owning the fruits of your own labor, then you owe your existence to others, you're constantly in peril, you're not truly free. And copyright scores well on this point. So copyright supports the independence of creators and the creative industries. Because of copyright, they owe their livelihoods and ability to flourish to finding willing buyers for their products, not to governments or powerful patrons or other state institutions. So this independence allows them to develop their ideas freely, but also it allows them to perfect their craft fully, leading to fulfillment as individuals and a full flourishing culture. Okay, second, property rights create a sphere of private action. The rights to use and sell, give away, share, or exclude inherent in private property help to enable private life and free markets. We have our own homes, cars, churches, computers, smartphones, businesses, and other private spaces. And that sphere of private action facilitates economic freedom, as well as working with others, cooperating in worship, in political and social action, or simply being left alone to live as we choose. And so once again, copyright scores well on this point. See, copyright facilitates millions of mutually beneficial transactions a day. That's why it exists. We hear all about litigation, but that's the unfortunate exception to the peaceful rule of productive cooperation. See, the investment and it enables, and the security and rights it creates enables a private market where people engage in free expression for their own enlightenment, edification, and entertainment. All right. Third, property rights support self-government. See, property owners have a stake in society. They have something to lose. They have a stake in representative government, and they're more likely to support it and participate. Once again, copyright scores well on this point. First of all, as Justice O'Connor once said, it's an engine of free expression. It helps generate the works that disseminate the ideas that lead to a productive debate that supports a reflective democracy and representative government. It also, interestingly, helps create a class of people who support free expression because they make a living off of it. Creators and media companies are the biggest supporters of freedom of expression in the legislature and the courts. So in sum, like any other property right, copyright provides essential support to individual liberty, free markets, and democratic governance. See the alternatives, and it's always about the alternatives. We'll support culture some way. Don't do as well. Government support, patronage, charity, or an existence eked out on ancillary revenue. These things don't do as well as property rights in securing liberty. All right, second, I'll say a few words about copyright as applied. Okay, first, the institutional details matter. The legal details matter. A lot of people don't get these in this debate. What many people don't understand is that copyright scope is actually very narrow. It protects expression, not ideas. If you write a book, I'm not free to borrow your words, but I can freely use your ideas and make them my own. In this way, copyright's a force multiplier for the dissemination of ideas. By getting works out there, ideas proliferate freely. And they proliferate freely because copyright's a narrow property right. If you ever doubt this, look at the year's entertainment, the best-selling books, the movie blockbusters, the TV shows. You're going to see the same buddy cop movies over again, the same boy meets girl romances, the same sitcom plots and jokes. And that's okay. That doesn't violate copyright. People own their expression, their particular way of expression, these time-tested ideas or even their new ideas, but they don't own the ideas themselves. It's a narrow property right. Okay, second, and I'll wrap things up here, is that copyright, some complain modern copyright's a product of lobbying, right? I think this misidentifies the problem. Modern copyright is a product of overregulation, and people lobby to protect themselves. We don't have too much property in copyright. We don't have enough. Copyright is rife with price controls, compulsory licenses. We have a great example is from the 1909 Copyright Act. It set a statutory license rate of 2 cents per copy per cover song recorded. 2 cents. That statutory rate lasted 70 years. 2 cents, 70 years. Since then, that rate has continued to be controlled by the government. It's gone up somewhat, but we've never had a free market in this part of copyright, in this part of the music industry. So when you have to live under price controls and compulsory licenses, when your livelihood and your property rights depend on government control, of course you're going to lobby. It's only self-defense. So, in sum, copyright supports free markets and principles. To the extent it deviates from free markets, the problem is not enough freedom and not enough property. Thanks.
Thank you, Mark, and Tom, you're up.
All right, well, thank you. It's an honor to be here. The joke about the German, I'm going to talk very briefly about some of the moral foundations, much of which were written in German by Kant and Hegel, so I ended up being the only person who ever translated them into English. There are three fundamental arguments that are given for intellectual property generally. The first is labor theory and desert. You worked really hard, so you deserve something. Either you deserve some kind of remuneration or you deserve a property claim. I'm highly skeptical of this. There are lots of cases where people work really hard and they don't deserve anything because they didn't produce anything of value, or it's very difficult to capture that. Think of reputation, for example. Do you deserve your reputation such that if you lose it, one could claim that a legal harm has been done to you outside of libel and other claims of that sort. Second is personality. This is much more common in European continental law than in common law jurisdictions, although it has been creeping into the American legal system as well. In French, it's called the droit moral, the moral right that you have. And the argument is fundamentally that the artist producing a painting or a sculpture or a book or something else, that it's an extension of the person's personality, that that's the foundation of the intellectual property claim, such that if I paint a painting, I then sell it, and you put it into an ugly frame, I have a claim against you. And in fact, this has been infiltrating American law as well. I think it should be resisted very strongly. And then finally, where you get most of the traction, certainly in Washington, D.C., are some version or another of utilitarian claims. That is to say, it generates more of something valuable. I'm also quite skeptical of that as well. I'm not sure we get a lot more hip-hop because we have intellectual property claims or copyright claims for them. Now, I'm skeptical also of the liberty claim, and this is an interesting case. You find the most robust debates among people who believe in the relationship between property and liberty. Property and liberty are clearly connected at a very deep level, but here's the problem. The property claim in a song is that Mark can say, I can't sing it. And that does seem to infringe on my liberty in a way that saying you can't come into my home or use my typewriter does not. So it's not obvious that intellectual property, or copyright in this case, is compatible with liberty because it's a restriction on my behavior, what I do with my body, with my rights, with my equipment, and so on. Now, I don't think this is the silver bullet to create more innovation, nor is it the worst thing in the world. So long as it's a right that can be legally traded, people can innovate around all the stupid things that policymakers do. And this is very much driven by rent-seeking here in Washington, D.C. I mean, the Disney Act is a clear example of this, a really grotesque violation of the fundamental ground rock that we were promised intellectual property law would be about, extending just perpetually the right of a company to its products. Let's look at a couple of other claims then. One, now let's shift over a little bit, I mentioned patents. I do not believe that patent law promotes innovation, and certainly not in the United States of America, where patent mills are now shaking down companies systematically. And I've talked to lots of people in that industry who have complained they are forced to sign non-disclosure agreements after they're shaken down by patent mills who come and say, we'll go away for $2.5 million or $500,000. No way is this promoting innovation. I don't think there's much evidence it promotes innovation in the arts either. Maybe, but I haven't seen any strong claims that I felt were empirically well-grounded. In terms of other claims, I remember sitting in on a meeting in Asia with lobbyists from Hollywood and Silicon Valley and pharma, and they tried to convince policymakers they had to adopt American intellectual property law. It was the key to economic growth in their countries. It was risible, in my opinion. And I was shocked that these incredibly well-paid lobbyists were so dumb that the one thing they did not talk about that was plausible was that trademark law should be enforced in those countries. Why? Because when people get bad drugs or other products, they suffer as a consequence. But they just insisted they had to adopt American intellectual property law to protect Hollywood and Silicon Valley, and the claims they made were simply not reasonable. In fact, these are often justifications for protectionism. And you look systematically at the claims that are made by the software industry and by, let's say, Hollywood generally, about harms that are done in countries where they do not have American standard protection for intellectual property or copyright. They calculate them on a very unreasonable basis. They say, we think there were 2 million copies of this movie sold. We would have sold it for $47, therefore our losses are calculated at this level. They take them to bodies to bring cases against those countries on the basis of really unreasonable calculation of losses. In a poor country, they're not going to spend $47 for that movie. They might have spent $1. And the appropriate solution in that situation is to have some enforceable system of price discrimination models. And that, I think, is where the action should be going in this area, that price discrimination should be beefed up rather than a ham-fisted approach to implementing U.S. intellectual property claims. So I'll conclude with that. I'm skeptical on the moral foundations. Lurking in the background is some kind of labor or personality theory, and I don't think that these hold up very well. They're largely foreign to the American common law system, and I think that we should reject them being further introduced. And finally, I'm skeptical, but not an extremist, on the utilitarian claims that we get more valuable innovation because we're extending copyright protections. I don't think there's much evidence for it.
Well, Stan Leibowitz, you're probably, first of all, thank you, Tom. Stan, you're probably the ideal person to speak to that point, as it would just be a mix, so the floor is yours.
Well, I could do that, but then I'd have to throw away my notes.
No, you'll get it.
So I'll probably come back to that later. I mean, I guess just quickly, I'm not sure why I would view the interference in your use of a copyrighted work as being any different than the interference in your being unable to drive my car without my permission. Okay, in both cases, your freedom to do what you want, if what you want includes living in my house, taking my car, and living on my land, it also restricts your freedom. I don't view it that way. I don't know why I view it differently for copyright. When I was told about this event, it is true, and it's sort of strange. There is as wide a variation among free market individuals as there is in terms of our views of copyright. We agree that markets work well. That's something I think everyone on this, among this group would agree with. And we like markets, and markets consist of property, and property gets transacted, and we presume that markets do a better job than alternatives, which would be having the government interfere one way or another, even though in reality we know the government does interfere with markets of real property. The question is, should copyright be treated different than real property? And it has always been treated differently in intellectual discussions. By the way, I'm an economist, not a lawyer. But it's not clear to me that it really needs to. My view has been for quite a long time, 3 decades. Copyright basically is just a form of property on a newer type of property than land, okay? Because until we had a printing press, there really wasn't any purpose in something like copyright. So it's relatively recent, much more recent relative to regular land. And so therefore, people still look at it as some strange new entity that's created by the government, okay? Because the government says, well, there's copyright. But we take for granted the fact that the government's out there protecting property, okay? And I'm not sure we should do that. If we didn't have the government protecting property, then we wouldn't have free markets, and we'd have anarchy or chaos or whatever else you might have in its place. The arguments that I've seen, and this is what I thought I'd talk about in 2 or 3 minutes that I have left, is both people who are not free market, their criticism of copyright, which I sometimes see repeated by free marketers, which does surprise me. So I have a list of 5 canards. I thought I'd spend 1 minute each, but I only have a few minutes left, so I may not even have a chance to do much more than just say what they are. Okay, the first story that I hear, which is not correct, okay, is that copyright provides monopoly, and that's bad. Monopolies are not as good as competition, and so we should be wary of it. But the fact is, copyright doesn't provide any more monopoly than ownership of my car provides me a monopoly on my car. Okay, it's not an economic monopoly. It's just the ownership over that particular piece of intellectual property, if you want to use that term. Okay, and it's no more monopoly than any other ownership is on anything else. Okay. Second thing is I hear sometimes that the copyright restricts creativity. Okay, because there are people who want to use someone else's copyrighted work in their artistic endeavors. Okay, and while there's some element to that's right, there are people that want to use someone else's work. The reality is you can create a work from scratch, and then you don't have to worry about copyright and violating anyone else's copyright. If you want to borrow someone else's characters or ideas or plots, okay, if you want to put your story and have Captain Kirk as your main character, okay, you're borrowing someone else's stuff. And you shouldn't be allowed to just use it for free, just as if you were borrowing someone else's property to build a factory on. Okay, this is not preventing creativity de novo. It's preventing borrowing without permission. Okay, so that's the second canard. The third one is that copyright only helps major corporations. Okay, and there's no doubt that some major corporations are supporters of copyright, and some major corporations seem to be anti-copyright. Okay, a large part of the electronics industry historically. But the reality is small guys benefit as well. All right, just as in most other markets, you have gainers, winners, and some of them turn out to have been the small guy, and some of them turn out to be big corporations. But, you know, just take a look at J.K. Rowling as an example of somebody who was pretty poor not very long ago, and now is very wealthy, and it's due to copyright. All right, so small guys make it. All the big rock stars, they generally weren't rich to begin with. Okay, it helps both parties. Okay, fourth one, copyright lasts forever. Okay, this was Larry Lessig's idea a while ago. Got a few Supreme Court justices basically to agree with him. Okay, that's crazy. It lasts longer than it used to. Okay, but it doesn't last forever. Okay, maybe it'll just keep growing, but I doubt it's going to reach infinity. And if it was, it's not clear to me that it's necessarily a bad thing. We can have a discussion about that. And then the fifth thing is that copyright limits free speech, okay, which I see come up from time to time. I don't know if anyone on this panel would go with that story. Okay, but it doesn't. It just sort of eliminates plagiarism, if you will. You can't say exactly what someone else has said without their permission. Okay, but you can give exactly the same set of ideas, just in your own words. Okay, I have seen all of these brought up in various instances in the past. Okay, and none of them are reasonable.
Stan, thank you. And now, so that we can engage these issues a little bit, we gave everybody a little bit of extra time on the first round, and I am going to try to hold people to about 3 minutes on the second round, which I know is going to be tough because now that the issues are on the table, I know that people would like to go at it. But Jerry, let me start with you. We'll go in the same order, and let me ask folks to pick out an issue or two and go for about 3 minutes.
Well, thank you. You know, it's interesting. I didn't hear much disagreement, right? So I heard a lot of things I agree with. One thing I didn't agree with was you were pointing out that your ability to restrict me from singing the song that you wrote is the same as you restricting me from driving your car. The difference, of course, is that if I drive your car, you can't drive your car. It's a rivalrous good, whereas if I sing your song, you can still sing your song, right? There's enough song for everybody to sing. So that's just one minor disagreement. But beyond that, I think there's broad agreement that copyright is property. Copyright generates economic activity and innovation that is good. What I think maybe hopefully we can get a little deeper into is the contours of that copyright. And I think it's interesting, Mark said, at the very top of his remarks, how copyright is completely compatible with a free market, and I think he's absolutely right. But I think you can I wonder what's the difference between copyright and, let's say, taxi cab medallions, right? So taxi cab medallions are property. Taxi cab medallions, you buy them. There's a lively market in taxi cab medallions. It costs about $1 million each in Chicago or New York. You can buy one. When you have one, you can will it to your son or daughter. You can sell it to somebody else. You want to restrict others who don't have a taxi cab medallion from driving on the streets as a taxi. It's an interest that you have, and you hope that the government will enforce it. And you want to lobby the government, as you say, if it's something's overregulated, you want to lobby the government to protect yourself, as you said. And so you want to, for example, keep the number fixed to where it is. Okay, so to me, using Mark's criteria, taxi cab medallions are property and they are compatible with the free market. I think it's absolutely true. What we have to ask ourselves is, why are we skeptical about taxi cab medallions, but less skeptical about copyright?
Taking away your free speech rights right now, and giving them to Mark. Mark, taxi cab medallions.
Wow. I have my own things I'd like to say, but I'll point out there it's not a hard one. Nobody created taxi cab medallions. They're a government regulatory entitlement. People create expressive works through productive labor. And that responds in part to Tom. It's a long debate. His view of labor theory is not crazy and not out of line. But there's another view of labor theory, that when one labors, when any productive intellectual labor, all labor is ultimately productive intellectual labor, where we impose our will and design to create something new in the world, that's where the labor claim, the property claim comes from. And that productive labor is how we distinguish from some of the harder cases Tom mentioned. And it's how that moral claim is how we distinguish from something created by government fiat and something somebody deserves to own. We say people deserve to own their copyrighted works because they've contributed something to the world and because they are engaging in labor and need to own that thing to live full, flourishing lives. One more point I'll make is that further in owning this kind of stuff and not letting others use it, yes, arguably we impinge on others' liberty when I stop them from singing my song, but it's an argument that proves too much, isn't it? All property rights impose burdens on other people's liberty. Your ownership of a piece of land makes me walk around it. You put a fence up, it imposes on my liberty to travel freely. It proves too much, and if our only understanding of liberty as advocates for free market and liberty is that I get to do whatever I damn well please, well, that's a 5-year-old's understanding of liberty. A grown-up understanding of liberty is ordered liberty. People have competing claims, competing rights that need to be reconciled through a system of ordered liberty. And that's what property rights do. And that's the kind of system we have under copyright. So yes, it's fully compatible with liberty.
Well, thank you. I appreciate the non-crazy comment very much. Let me address a couple of things. The first thing that's really important is this issue that Jerry mentioned about rivalrous use versus non-rivalrous use. If you use your toothbrush, which is yours, I can't use it also. That's a good reason to have property claims because it avoids conflict. Go to poor countries around the world. What do you find? Poorly defined or non-enforced property claims in water, land, grazing rights, forests, and fisheries. And what do people do? They're constantly fighting over these things, over these claims. Property rights allows us to live together in peace. That is what liberty is very much about, and that's what property accomplishes. But I don't think that that argument carries over to some guy in Pakistan singing the song that I wrote. I don't see this as an infringement of my liberty that the other person goes down the street humming a tune or sings it on the radio or sings it on a television show. So I think these are really radically different claims. And what it came down to, again, as Mark pointed out, it's this, I'll mention crackpot theory then, of labor, that you deserve it because you worked on it. Well, people work very hard in the fashion industry. People here might scoff at them, but fashion designers pour their life and their energy into fashions. How horrible that they don't get intellectual property protection of the same sort that J.K. Rowling does, for example, for their fashion work. Why not? Why not allow fashions to be copyrighted in the same way as the text? Mention one other thing. The United States did not offer intellectual property or copyright protection for foreigners until relatively late in American history. Charles Dickens made much more in the American market than he did in the British market. He had no intellectual property protections whatsoever in the American market, and consequently they used the market mechanism in the form of forward contracting with bookstores and all sorts of other mechanisms, and he made much more money in America. J.R.R. Tolkien is another one. At the time that his books appeared, it was required that you register, and his American agent was incompetent, did not register. And you may have noticed, if there are any people here as kids read all of his books. On the back it said, those who, I don't remember the exact language, appreciate the rights of living authors at least will buy this and no other edition. And through his entire life, there was only one pirated edition, although it was legal, of The Hobbit that appeared in 1,000 copies. So he was able to make a lot of money without that. So I'll just conclude. Last point, free speech, Scientology case. This does seem to be a case in which critics of Scientology are blocked from criticizing Scientology because they claim a copyright in the sacred texts. So that would be, it's on the margins, but it does seem to me it is a free speech case.
Stan?
Okay, well, first of all, you can sing a song, okay, without violating copyright. The question is whether you want to sing it publicly in front of a large audience or whatnot, put it on a record. The issue that's come up a few times, which is more important, I think, is this question of rivalry. And it's true that the intellectual products are a category of goods which are what we call non-rivalrous, meaning one person's consumption doesn't reduce the ability of other people to consume the same good. All right, so you can listen to a joke or a song, and it doesn't reduce anyone else's ability to listen to the same joke or the same song. It can be repeated over and over. It doesn't get used up. Okay, but the question is whether or not that should be crucial here. Let me give you a hypothetical. Let's say your car is a private car, but it depreciates. Let's say it depreciates by time, which it does, and not by use. So every car is going to last for 5 years, and then it's just going to fall apart. Okay? Should someone be allowed to say, I'm going to use your car at night while you're sleeping because it doesn't interfere with your usage, you're sleeping, and it doesn't do any harm to you? And according to your logic, sure, why not? We should allow the people to be able to do that because there's no reason not to. It doesn't cause any harm. If you believe that, well, it's one thing to say you have private parties.
Jerry, go ahead.
Well, simply to say that it does interfere with your private property rights because you do always retain an option to use your car at any time, and that's a valuable property right, that option is, and so you should be able to sell it because it is rivalrous.
I'm not saying it shouldn't be something you can sell. I'm saying should people be able to take it from you without, just come into your garage and take it whenever they want, at night. You'd be in favor of that.
And my point to you is that it's not the same thing. If somebody
As
takes,
I've set
if
it
somebody, as you said, I'm rejecting your hypothesis, your
How's it
hypothetical, because if somebody comes in and takes it at night, they are interfering with my option to use it at night, to wake up in the middle of the night.
Hypothetically, you're sleeping. I already said it.
It's sort of embedded in sleeping. There's a possibility you can awaken.
No, hypothetically, you're sleeping.
I reject your hypothetical is not very good.
Stan, you're still on.
Okay, I'm not. And the last thing, yes, it is true there are ways around copyright, which the non-American authors used. There's a famous book which you may be referring to, which talked about a lot of these by a British economist in the early 1900s.
Arnold Plant.
Arnold Plant, that's right. Ronald Coase's teacher. But if you read his work, you'll see that the numbers that the British authors got were less than they would have been expected to get given the population of the U.S. by a considerable margin. The U.S. was really quite a bit bigger than Britain was as a market. Okay, so there were ways around it, okay, which is by being first, which doesn't work very well anymore because they can make copies so quickly, which they couldn't do then. All right. So yes, that was providing their own version of copyright. Okay, by being first, they got protection until somebody else could come up with a second copy. But that's still a form of protection. Without that, they would have gotten much less. That's at least the expectation. And Charles Dickens hated the fact that the U.S. didn't have copyright. Okay, he was he antagonized all the Americans on a book tour, and all he did was want to talk about how terrible American copyright was. So he wasn't that happy with how things were.
All right. Well, we have about 45 minutes left, and we're going to now turn to the other participants here at the table. We haven't scripted this out, so I'm going to ask folks to, I think these will stand up, my recollection. If you would like to be recognized, stand your name tag on the side, and make sure you do it where I can still see your name. Rob Atkinson, I was actually thinking of calling on you first anyway, so I'm going to give you a not entirely conservative perspective on copyright, but you're welcome.
Close enough.
Welcome here.
All right, well, thanks, Jeff. So I just wanted to respond to a couple of points that were made. One is this non-rivalrous thing. I recently went on vacation to Disney World with my wife, and we found an airplane that wasn't full that day, so we snuck on and got 2 free seats. And then when we got down there were a few hotels that weren't full because it was in the summer, and so we were able to sneak into the hotel and use the hotel rooms. Then we went to this great IMAX movie, which is only half full, so we snuck into that too, which was perfectly legal because it's non-rivalrous. We weren't hurting anyone. So I think it's fine. It really helped our liberty a lot and helped our pocketbook. The taxi cab medallion example, I think, is really fundamentally not the right example. The analogy of the taxi cab medallion would be essentially for the government to produce a medallion for movie makers, and you can only make a movie if you buy the medallion. That's the analogy. That's not anything what we have here. Anybody can make a movie. You go on YouTube, millions of people are making movies now. Some people make movies under copyright, some people make movies not under copyright. So I just don't think it's the right example to make this. The point that the gentleman here on the far right made about patents, I would encourage you to go to talk to any Silicon Valley venture capitalist and ask him whether they're willing to fund a startup that doesn't have intellectual property protection, because the vast majority of them will say, no, we're not willing to fund that, because they understand that if they don't have intellectual property protection, that the company's not going to be able to monetize its invention. And then the last point is this notion of sort of the incentive component of this versus the rights component. So the incentive component of copyright has basically no effect on me. I've written 3 books, and I would have still written the 3 books if they were not under copyright, because I'm not writing them for money. But a good friend of ours is a professional writer. He supports his family by writing books. If he didn't have copyright, he would not be an author. He would not be writing that. So this notion that somehow there's no incentive there, I think is just false. And when it comes to the rights, I actually, I would be quite upset if someone were to take my book and publish it under their own name, even though I'm not in this for the money, and I may make very little money from my books, although my book is being translated into Chinese this week under copyright, believe it or not. Although my first book is pirated in Chinese, so I now will make large amounts of money in China. The point is, it is still my property, and I have a right over who uses it and how they use it. And so it doesn't matter whether there's an incentive component to it, there is still a rights component to it. Last point, 20 seconds. I find this whole debate troubling, because the conservative side of the debate troubling, because it sort of seems like a race to the bottom of who can advocate for getting rid of more government than the other person. So, all conservatives can agree on taxi cab medallions, which I would probably agree with too. I don't think they're a good idea. And, certain types of regulations on air quality. But that's okay. So I can go one further. Let's get rid of government regulation of property, intellectual property. Isn't that even more libertarian? And I think our 2 colleagues here who were defending copyright, I think, had the right answer to that. That no, it is not, because it limits if you didn't have those things, you would end up actually with more government rather than less government.
Rob, thank you. Jay Rosenthal, and Jay, will you introduce yourself, just where you're from? So,
well, I think we can get this going here. Yeah. All right. My name is Jay Rosenthal. I'm the Senior Vice President and General Counsel of the National Music Publishers Association. And for about 30 years, when I was in private practice, I represented artists and labels and some rappers and many, many different companies engaged in owning and exploiting copyrights. While this is a marvelous debate about cab medallions, I think I want to talk about songwriters. And just a little fact, and then to talk about copyright policy, philosophy, and where we go with all this, especially from a conservative standpoint. In Nashville, about 15, 20 years ago, there were about 3,000 standalone songwriters. Because of all sorts of problems with copyright and with piracy, which is part of the whole problem too, there might not even be a couple hundred. We have lost a whole generation of songwriters. And the founding fathers, when they put the word progress in the copyright clause, they weren't thinking about amateurs. They weren't thinking about user-generated YouTube videos. They were thinking about creating professional authors, professional artists. And they were thinking about, when they finally got around to music, the Bachs and the Monteverdis and Charles Dickens with books and all of that. What we have here, effectively, is a situation where copyright has come full course of, while it's supposed to protect property interests, and I thoroughly believe that. I totally disagree with Mr. Palmer and his theories about he doesn't see much empirical evidence. If you have a songwriter and they get money from the writing of a song, they're going to continue to write songs. if they don't get money, they're going to go back to work at McDonald's. I know that because many of my clients who haven't been successful for one reason or another have done that. They don't create works. That's not progress in my mind. Now, as far as conservative theory and how to fit what's going on out there, you can have and be supportive of property interest in copyright and yet be critical of the way government has been involved, in particular the compulsory license. Our organization has recently come out in favor of creating a conversation about repealing the Section 115 compulsory license, which is all about a mechanical reproduction right for a song. This is what the users would pay for the rights to do this. And we really have come out with this because of much of what Mark has said, which is that in 1909, for reasons that are highly questionable, a compulsory license was imposed on songwriters and music publishers and not on the owners of the sound recordings. And what that has led to is the most incredible disparity of value and undervalue in the marketplace for musical compositions that we will ever see. I can go through all sorts of statistics as to how undervalued songwriters get, but it was 2 cents in 1909. Right now it's 9.1 cents, and in the last Copyright Royalty Board proceeding, the labels tried to get it down to 6 cents. They are not subject to a compulsory license, songwriters are. If I were to focus on anything as it relates to conservative theory, it would be on should we have compulsory licenses? Perhaps in some instances, they're more valuable than others. Under Section 114, I think there is an argument for non-interactive public performance of sound recordings. But in other areas, it's time to let the free market work. And I think Mark said it. The reason that we don't know how all of this plays out is because we've never had a free market. And I think it's about time, and I think that this is something where conservative theory can really get a grip on and move forward. Let's get rid of some of the compulsory licenses. Thank you.
Jeffrey Bloom.
Thanks, Jeff. Jeff Blum, the Deputy General Counsel of Dish Network. And I think it oversimplifies things to compare copyright to a car or piece of property. If AEI was holding a seminar on the law of trespass or grand theft auto, no one would be here. There's something unique about copyright, and it's not so much what is a copyright, but how you infringe. And I think if you look at the past 90 years, copyright holders no doubt deserve compensation for creating their works, and Jay's publisher clients deserve that. But what does it mean to infringe? If you look at the history of how the content community has gone after technology that ultimately helps consumers, I think that's a very important lesson that hasn't been addressed. They challenged the phonograph as potentially destroying their business. They challenged the VCR as the end of copyright as we know it. They challenged the DVR, the remote DVR. They challenged our wonderful commercial skipping technology called AutoHop. And they challenged Aereo and were victorious in Aereo, but in all the other cases, they weren't victorious. And the courts, I think, in those instances, recognize there has to be a balance. And ultimately, as a consumer, if you're paying for content legitimately and not stealing, if you're stealing, I think everyone up here would agree that's copyright infringement, and that's wrong. But if you have legitimate access to content, shouldn't you have the right to record it when you want? Shouldn't you have the right to skip commercials? Shouldn't you have the right to watch it remotely on your iPad? And I think, as the discussion of copyright goes on, the consumer and the impact on the economics of the consumer and technology are really important. And as the courts are looking at this and trying to draw that line, that's going to be where you as a consumer are ultimately going to be impacted in terms of what choice you have, what's going to be invented, what's going to be invented and shut down if the broadcasters and programmers win the case. And that balance, I think, is important to both promoting the economic good that comes from copyright, but not going too far and stifling innovation and the economic good that comes from that.
Right. Tom Sidner, and then I think Neil has his sign up, but we'll go with Tom first.
Thank you, Jeff. I just wanted to actually correct a few things that were said that are probably not accurate. I think in these debates, I guess what I would most likely to see is to see them move forward and move forward past some of the tired and inaccurate examples that we have seen for too long. I have become far too familiar with certain things that were said today that really we really need to be able to move past. Are copyrights like cap and trade? No, they are not. In setting copyrights, does Congress have to act like Soviet central planners? No. Soviet central planners had to prescribe outcomes, how much of what was produced. Copyrights don't do that. It is a tradable property right. And all it gives you is if you create something that actually does have value, then you can have some control over how it is disseminated. If what you create does not have value, the copyright is worthless. There is not, the analogy to central planning, very simply, does not work. And I also have to note that when we talk about the first Copyright Act, the Copyright Act of 1790, the notion that it didn't protect plays and music is simply wrong. They were generally disseminated in the form of books at the time. Most of the early books in in late 18th century America were actually books of musical compositions, and they were protected. And the other thing about the Copyright Act of 1790 that I think is critical to understand is that it was the first market-focused Copyright Act that we had seen. It's not the first modern arguably modern Copyright Act. That's British Statute of Anne. But the Statute of Anne has a general compulsory licensing provision in it. Queen Anne and the British Parliament in 1710 just did not trust market mechanisms. The Copyright Act of 1790 does not have a general compulsory licensing provision in it. The framers did trust markets, and we should follow their lead. The other thing that, one other point I just have to make is the claims about the quote, the Disney Act and the extension of copyright term, just plain wrong. And I think it's, I'm particularly surprised to hear someone fluent in German say that, because our current norms for copyright term, and of course the framers looked at then prevailing international norms when they created our Copyright Act. Our Congress did the same thing in 1976. The prevailing international norms for copyright term are prescribed by a treaty called the Berne Convention. It's called the Berne Convention rather than the Hollywood or Nashville or New York Convention because it was negotiated in Europe by Europeans. The term provisions in it took their current form in 1948, and the United States was not there. We were not a party to that treaty. Mickey Mouse had nothing to do with it. And in those term provisions, France and Germany wanted to, they could get agreement on a term of life plus 50 years. They wanted it to expand to life plus 70 to accommodate the increasing span of human life. So they had a little departure from national treatment written into the statute. It was designed to encourage and move from life plus 50 to life plus 70. The European Union invoked their right to encourage others to do so. We followed suit. It is something that happened as a result of the development of prevailing international norms. We actually were not really involved in it, truthfully.
Last point.
Yeah, and I mean, I think when we move, my point would just be, let's move this debate forward. Creators and disseminators of expressive works are producers of complementary goods. There's no fixed way to tell exactly who contributes how much to the values that consumers enjoy. The way that we as policymakers can ensure that this system works is make sure everybody has exclusive rights that are enforceable. It's a practical matter. They'll have every incentive to work it out in the market.
Okay. Neil, you're next.
Hi, I'm Neil Fried with the Motion Picture Association of America. I think I just want to point out that the constitutional principle behind copyright is that it is ultimately good for the consumer. It is good for the public. That in recognizing the property right, in rewarding those who create things, you get more of it. You get more content, you get more innovation. Essentially, you are creating the marketplace. And what that marketplace does with that property right is allows an almost infinite variety of relationships to be entered into in a marketplace. Consumers, producers, distributors can all arrange their own relationships as technology changes, as consumer demands change. And it is working remarkably well. In just 2013, there were already 100 legal online video services, and consumers were using those services to access 5.7 billion movies and 56 billion television shows. Copyright drives innovation. It spurs everybody to create more in more innovative ways to generate a marketplace. And I think this notion that there's somehow a balancing that needs to occur because copyright is somehow antithetical to consumer welfare is a mistake.
I think Mark wanted to have a few points in rebuttal, and then we're going to go to the audience. And Mark, I'm going to ask you to stay short.
I will.
To stay brief. And I see Larry's got to sign up, so we'll go Mark and then Larry, and then in a second you'll all be thinking of questions because we're going to turn to. I got another one. Ryan is up. All right. Then we're going to get to the audience. All right, Mark.
I think Tom and Neil have already done much of the work in what I wanted to say, but I wanted to definitely push back against the narrative that the creative industries and innovation are at odds. As they pointed out, the creative works, the creative industries, copyright serves as a platform for innovation. Not only is the motion picture industries widely licensing their content on the many platforms and innovating themselves, so are publishers. So is the music industry. And indeed, individual creators often invest huge sums. Think of George Lucas and James Cameron investing hundreds of millions of dollars of their own money to create really great new technology that has continued to create the terrific movies we all enjoyed to improve them. So there is no inherent conflict. Technology improves a lot of creators, and copyright encourages innovation through the development of new technology.
Larry.
Thank you. Larry Spivak from the Phoenix Center. Jeff, thanks for inviting me. A couple of quick points after listening to the discussion. We've done at the Phoenix Center a lot of work on digital piracy, and what strikes me as listening to this conversation is that, and just the copyright debate over privacy generally, is that when you look at, with the advent of technology, the ability to make a costless copy immediately is part of the issue that we're having here. But as my partner, chief economist, Dr. George Ford likes to say, free is never the right price. And that's what we're dealing with now. And we've done a lot of studies lately that show, you wouldn't think you would have to do these studies, but that, theft is not costless to society. And it echoes a lot of the comments that people are making now. I mean, if I invest a lot of money into making a film, if I invest a TV show, music. Ricky Skaggs was just at the National Press Club a couple months ago. I actually translated it, if the best way to describe it, in a blog that I did. It's rather long, but he was basically talking about how somebody reaching in my back pocket and stealing my money. You're having a qualitative diminution in creativity, and therefore, society's not bad. So, but going though, I think to the point of this conference, and just want to raise this real quick, and to prove my bona fides, I did wear my Richard Nixon cufflinks as the topic is conservatives. Having a lot of these debates lately, there's a lot of discussion from free marketers who claim that copyright is antithetical to laissez-faire economics and it creates a monopoly. Last week, we put out a paper which looked at sort of the giants of conservative and libertarian thought. Ludwig von Mises, who is a mentor of Frederick Hayek, Milton Friedman, and Ayn Rand. And all, at least according to these three giants, copyright is completely consistent with laissez-faire economics as well as, and it does not create a monopoly. And what's interesting, if you look at the Justice Department's IP guidelines, they find that it doesn't create a monopoly. So I think the discussion needs to change a little bit. Thanks.
Right, and Ryan, I think you're going to be our last commenter from the table here before we go to questions.
Thanks, Ryan Radia from the Competitive Enterprise Institute. Jerry and Tom portrayed copyright as a social tool designed to increase output of something that we think we're not otherwise going to get enough of. I think that's incomplete. Look to property law. Over a long time, governments have developed all these rules that limit property law to overcome problems. As Chris Newman has explained, things like adverse possession, prescriptive easements, the necessity defense, numerous clauses, good faith improver, deed recording statutes, the list goes on. What these all are designed to do is make property work better by putting limits on how we use it. Applying that to copyright, the goal is not to subsidize an industry that we think is valuable, but rather to bring us closer to the optimal amount of the creation of intellectual works that we would otherwise get, but for the fact that it's very difficult to have things like effective digital rights management that, or to enforce contracts between sellers of intellectual property and their customers, where you have a high degree of costs in enforcing and identifying people who infringe. So copyright is designed to overcome that problem. It doesn't always do so effectively. The question whether we should propertize a particular asset like copyright or fashion designs is a fact-specific inquiry. There are many things that people create that we could propertize that we shouldn't because the costs are too high, the downsides are too great, or because things work pretty well otherwise. To me, that the copyright meets that test today, but it might not in the future. In a world where we had nearly perfect, nearly costless DRM, we might not need copyright, or we might need much less of it. But for now, copyright seems to be a legitimate tool to bring us closer to where we would be in a market where free transactions work better. But it's not a question that could be answered with first principles.
Well, Ryan, thank you, and thanks all of the folks at the table who participated. I see James over here has a microphone. So if we've got, and before we go to questions from the audience, what I'm going to ask for at the end here in about 10 minutes or so is we'll go in reverse order. We're going to give Jerry the last word, and that means we'll start with Stan, and then Tom, and then Mark, and then Jerry for closing arguments as it were. But in the meantime, we're going to mix it up for a few minutes around questions from the audience. I saw one back here in the middle in the red shirt. And please, again, announce who you are. Please introduce yourself.
Hi, I'm Roman Gares. And I work for the Federalist Society. And one of my hobbies is I'm a stand-up comic. And jokes are not actually subject to copyright. And like most performance arts, stand-up is harder than it looks. The average 1-hour special takes about a year to develop for a professional comic. It's very easy to steal. There have been a lot of fights over it in the industry. My question is, there's been a lot of discussion about rivalrousness and goods, whether it's more like a car or whether it's more like singing a song. You know, the joke, I just flew in from New York and boy, are my arms tired, used to be hilarious, but it's been told so many times, not so much anymore. A lot of comedy and a lot of creative work depends on novelty and being able to perform it in such a way that you reach the market with it first, and you were able to have it associated with your brand. So doesn't that mean that we have to consider the relationship between the public and the creative work in a way that we don't with other property that we can cart around?
That's a good question. Jerry or Tom, I think that might have been a question for one of you.
I just think it's worth putting on the table. There's a lot of innovation without intellectual property protection, and the burden of proof is on those who would claim we wouldn't have innovation without it. And as I said, I don't know the answer to all these questions, but I'm skeptical of what the paid lawyers of the people who own those property claims make in public. I'm just a skeptic about it, and that's it.
I mean, to echo Tom, to me, comedy is an example of why we might do with less copyright than we have today in other areas, because there is no dearth of fantastic comedy available to Americans. And what is that? Okay. The other thing I would point out is that, as you mentioned, within the comedy community, norms develop to sanction those who steal jokes. And so I don't think it's a rampant problem that that prevents innovation in comedy. I think we see a lot of comedy, a lot of innovative comedy, and it's all without copyright. It doesn't mean we shouldn't have copyright anywhere else, but it sort of raises the question: does more copyright get us more expression, more innovation?
Stan, I think one of the
Yeah, there's in economics something which used to be known as the law of supply, but basically said supply curves were upward sloping. Right, now this is a very fundamental, not always true, it's not a law anymore, but generally accepted proposition, that when you raise the price of something, you get more of it. The argument that I hear from people who are hostile to copyright, more so than you guys, is that you don't need copyright. These people are going to produce it anyway. Look at all the people writing songs. There's actually some empirical evidence that more songs are available now, created every year, than was the case before. Okay, but the problem is that they're confusing what used to be garage band songs with professionally created songs. A lot of people don't like that distinction, but we used to have a lot more songs than people knew about. The fact is that on this, I think the burden of proof should be, since every other market we look at, we think that when you increase the payments, you get more of it. The burden of proof should be on you to show that, in fact, you get less or you don't get more. For one thing, people can work full-time when they're employed. And when they're working full-time, you expect them to be able to produce more. And you also expect the time they put in to have something to do with the quality of what comes out, not just the quantity.
And I'll just say briefly, these markets we're talking about, jokes, comedy, and fashion, they're not bereft of IP. There are aspects of them that are protected by copyright, and certainly they're protected by trademarks, and sometimes, in the case of fashion, trade secrets. And so there are ways in which the intellectual labor is being protected. Second of all, sometimes norms can work, and the research by Sprigman and Rastulia show a norm system in jokes. But there's two things that I think are kind of sad about the norm system for protecting jokes. One is that sometimes when the system fails, there aren't just fights, as you alluded to, in the figurative sense. In the literal sense, there are beatdowns in the parking lot. And I think, Sprigman and Rastulia kind of refer to this with a bit of a smirk. It's not a smirking matter. Property rights exist, as Tom talked about, to stop violence, to prevent violence. And a second point is they work among the weak, or people with about equal power, but people like Carlos Mencia and Robin Williams, notorious joke stealers, get away with flouting the norms, ignoring them. Why? Because they're more powerful. Normative systems don't always protect the weaker against the strong.
Do we have more questions from the audience? I see one over here in the corner. As far away from the microphone as you could possibly.
Hi, Jared Meyer, policy analyst at the Manhattan Institute. And I wanted to ask people who think that we need stronger copyright protection, how you can say that it's not unbalanced currently when Miley Cyrus owns the rights to her songs for longer than if I cured cancer. I mean, it seems as if we're looking to incentivize something, or if we're trying to make it, how much value you create, something along the lines of patents it's easier to make that argument than copyrights, that they need more protection. And also, I mean, Jerry brought this up at the beginning of retroactive extension, so I wanted to get thoughts on that and see if anyone could have a semi-feasible defense of retroactive extension.
So I'm going to let, who wants to jump in first on this?
I can take it if you want.
Go ahead, Tom. Although let's let folks on the panel go first. Is anyone on the panel?
I'm sorry, go ahead. Panel?
I've got no takers. I'm going to have an opinion on this too,
but
go ahead, Tom.
Let him go.
Oh, great! I get the tough issue. Well, let me just say this: I've talked to a lot of copyright owners. I think, and what I have frequently heard them say is, if they could get the 20 years of virtually exception-proof protection, almost utterly ironclad, virtually no limitations or exceptions that you get in the case of patents, idea and expression, they might take that deal because the rights become very hard to enforce. Copyrights and patents differ fundamentally for exactly the reason it was mentioned earlier, and that's that the scope of the exclusive rights granted is radically different. And they also differ, quite frankly, for historical reasons that have, I do think, something to do with something Tom mentioned about sort of a rights of the author approach. Ever since copyright law came along, it has been based on the idea that copyrights should, as a general matter, last for the lifetime of an author and for some post-mortem period. The principle used to calculate that post-mortem period has changed over time, but the basic principles never have. From the beginning, copyright term was not just a term of years picked out of a hat. It was supposed to implement principles, and that differs from the patent context. As for retroactive term extensions, we have essentially now 2 Supreme Court cases on that actually read heavily on the issue. Eldred And then Golan also significantly reads on it, noting that there were indeed reasons, good reasons that Congress could choose to do that. Did not have to, but could choose to, so that you didn't have people trying to game the system if they thought the term, delaying publication so if the term might change.
Tom wants to get in on this, but I'm going to make one comment, and then we're actually going to start down and go ahead and do the closing comments, so we've got time to do that. But let me, as an economist, the question I've had about the length of term issue really goes specifically to the mouse. And so I understand that Walt Disney is no more likely to have created the mouse because he thought that the copyright term would be 70 years plus life of the author than he in fact was when the copyright term was shorter at the time he did it. But I don't think that's the economic event that we're trying to affect. The economic event I think we're trying to affect is whether Disney continues to invest hundreds of millions or billions of dollars in things that people value, all of which is enabled by its ability to appropriate the part of the value created by doing so through its copyright of the mouse. And so there's this element of continued investment, which isn't the case in each and every new work, but does seem to me is the case in that example and probably other examples, maybe no example we could think of better than that, but lots of examples that are like that in kind. And one of the things that's been talked about is the notion that rather than having an automatic copyright lasting forever, one might have to reapply, and we had that system, I think, for some copyrights in the U.S. But as an economic matter, it seems to me that that goes at least to what Tom would call the utilitarian argument. The question that what we're trying to do here is incent productive activity and allow people to reap the rewards of productive investments that they make one way or another. So that's my one substantive contribution here. And having made that one, I think we're going to start with Rob, who's got 30 seconds. He wants to throw it, and then we'll start with Stan.
The difference between Miley Cyrus and cancer is nobody really cares whether you can not access, whether other people can use Miley Cyrus. It doesn't matter, really. It's just simply a piece of one unique thing. Patents are completely different in the sense of patents, the idea is to spur innovation, to give an incentive for it for a limited period of time, and then to open that innovation up to other people so that other companies could develop derivative products around it that would then spur innovation. That's very, very different than a copyrighted work, which we don't really fundamentally care whether Miley Cyrus is open or closed after 50 years. What difference does it make from a societal perspective? Patents are completely different in the sense that there's a huge societal benefit from opening that up afterwards.
All right, we're going to try to go about 2.5 or 3 minutes each, and starting with Stan, we'll go in reverse order from how we started and go down the road with closing arguments. Stan?
Okay, yeah, everyone on the general panel's free market, I prefer that term to conservative. And that generally means you're suspicious of government because the government's always trying to interfere with how markets work. And so there's this natural tendency, I think, among the people here to not like when the government starts to intervene in markets. But one of the things that it's easy to forget about is that for markets to work properly, for free markets to work, there's something going on that we're assuming, which is that there's some organization, generally the government, making sure that the rules are being followed by the market participants. Okay, so contracts are being enforced. There's some mechanism to sort of adjudicate what's going on in contracts, and property rights exist and are enforced. And that's generally the role of the government. And so if you actually believe in free markets, you don't talk about it much, but there is this general underlying belief that something is allowing the markets to work, and that something happens in this case to be the government, even though normally we always think the government's only doing interference with the market. I think that's what causes a lot of the difficulty in the case of copyright. The people like, such as myself and Mark, view copyright as essentially just a property right, and the government is what we expect to be in place, sort of making sure that property right exists and functions. And the other two members of the group just view, the government's coming in here and creating something, they're doing something, and they view that as interference instead of just the creation of a market. And that's what I think the difference is. I'm not sure there's a easy resolution for that, except I'm right.
Tom?
I'd like to address quickly an issue that was raised by the gentleman to my left here. Would you invest as a venture capitalist in a firm that didn't have any intellectual property protection? No, of course not, because we have an intellectual property system. One of the problems you would have, and I was involved in a small startup that ended up fizzling a bit, was if you don't protect it, you run the risk someone else is going to do it, and you're bounced out of the market. So a great deal of activity in the legal system is a response to the law. This should hardly be surprising to anybody. In patent, well, that was the issue that was raised, was in patent questions. So it's clear people respond to the incentives that are created. And I'm not saying we should raise them to the ground. We should be very skeptical of those who want to constantly extend it. The retroactivity, I think, really was a grotesque violation of the rule of law. And the claim that was just raised, well, this created another incentive. Well, if you want to do that, do it from this point forward. Say, now, Mr. Disney or this Disney Corporation, for all the movies you create from this point forward, you get these rights. But to retroactively extend it on something created years in the past, I think really was shocking. And it was a big warning bell about the dangers. Lastly, on the question of innovation, a classic example of how we see that claims made about innovation are often set in a particular institutional setting. Look at the aircraft patent system. For decades and decades, there was a compulsory patent pool going back to World War I that said if you innovate, you must put it into the patent pool, but then you have access to all the patents in the pool. And the consequence is it was effectively the same as no patent system in aircraft design and engine manufacturing and innovation. Well, it would be hard to say there was no innovation between 1917 and 1985 in aircraft design, despite the fact there was virtually no system of intellectual property protection, or very, very limited and weak one. And I think the same thing goes in terms of art, books, and so on. The argument is we're going to get more great works. Well, maybe. I'm not sure that these pop artists are advancing our culture, but that's not really the function of the law. The law should be about establishing clear rights that everyone can understand. We can contract through them. We have the rule of law. We can buy and sell them. Once you get it, don't screw around with it and start making them retroactive or extending them in various ways, because you're responsive to concentrated interests that impose burdens on the public. So that's why I'm a skeptic on this issue, not an extremist or a radical, but highly skeptical of these efforts to constantly advance copyright protection.
I'm not sure it's on anymore. It went off. Maybe we worked the wire loose. Okay. I'll make a few related points. One is I appreciate what Stan said. Some of this is a reaction to the role of government. And let me say something that's perhaps heterodox, but I don't think at AEI that government does good. And, you know, I've done a lot of work in the developing world in recent years, and I've come to appreciate this. I don't know that Tom had the same reaction, but a lot of the free market advocates and people who might identify as libertarians I meet in developing countries with failed governments, I don't think they're anarchists. They know what anarchy looks like. And government does some good things, legitimate things, enforces property rights, enforces contracts, enforces the rule of law. So just smearing something with a government brush doesn't end the argument. This is an effective institution. What you have to ask is, why do we have a right? When should the government act? And that's when you have to look to the moral basis of a right. And that's how we distinguish the taxi cab medallions from copyright, because we look to some moral justification. And here we see people who are engaging in productive labor, pursuing their liberty interests, living full, flourishing lives through their ability to control their property. I'll just make two more actually quick points. I think the focus on term is a bit of an ideological red herring. It's a prudential matter how long the term lasts. It's one we can argue about, but it's not a fundamental justification issue. And it was a matter of trade policy when we adopted the term we did. There was a reasonable argument for it. There's a reasonable argument that it's too long. But in one sense, perhaps we should have that argument after the effective term is more than 5 minutes long, because that's about all your copyright term lasts for with today's enforcement. Third, my last point I'll just make is it's been stated sometimes in the course of the discussion that there's no empirical support for IP rights. That's an increasingly outdated assertion. Sure, there's studies on both sides of that issue, but Stan has done work, empirical work, that often shows a positive relationship between IP rights and various economic indicators. And the international work, various authors, Walter Park at American University, Doug Lippold at the OECD. I've worked with Doug Lippold on the OECD on empirical work. We've found a positive relationship between IP rights and various economic indicators. The work's out there if you look for it.
Jerry.
So I first have to say I'm kind of shocked at what I just heard Mark say, that length of term is prudential matter and we can just debate that, but it's not that big a deal. Well, that's what I've been saying this entire time, which is kind of surprising to me. I think copyright is obviously property. I think copyright fosters innovation, etc. I don't think I'm too far off from where Mark is or anybody else on this table is. The difference is that I think the contours of that right that we create, the length of the term, whether you have to request it before it's granted to you, whether you have to renew, these things matter, right? It could be very little, it could be a lot. And where we set that dial is the crux, to me, of this debate, not whether, this is a moral right about just desserts or not. So that's number one. And at the risk of leaving here remembered as the taxi medallion guy, I'm going to bring that back up again, because I think it gets to the heart of the schizophrenia I see among conservatives and libertarians and free market folks when they're looking at these different privileges. And I think you absolutely got it right when you said that the distinction here, the key distinction here, is that some people on the right see copyrights as property, others see it as a privilege. And copyright is absolutely a privilege. The Constitution gives Congress the power to create copyrights, right, and grant copyrights to authors. This means that tomorrow, having that power, tomorrow Congress can, if it chooses to, write a law that repeals the copyright statute, and we no longer have copyright. Okay, Congress cannot similarly write a law that repeals property rights in yourself, property rights in your personal property. Right? That would not be constitutional. It gives you a hint, right? So it is like a taxi cab medallion in that it is a government-created statutory property. It's a privilege, okay? It's analogous to taxi cab medallions. Is it the same? No, of course it's not the same, but it is analogous in that it is a privilege. And what we hope we should be debating, to get to Tom Sidnor's point about getting past the tropes that we keep pulling out in this debate, is where do we set the dial? Is it at 0 or is it at 11? Right? I think it's somewhere in the middle, and I think we're way closer to 11. Thank you.
Well, first of all, please join me in thanking our panelists and all of you for a great we've managed to have this discussion at sort of 50,000 feet, and I hope that's been useful and interesting to people. We've managed to stay away from almost all of the kind of immediate policy issues, and there are lots of big ones in play, but we thought it would be useful to do that. Now and again, it's useful to step back and think about first principles. Thank you all for participating today. I can assure you there will be more events and more work, among other places, on techpolicydaily.com addressing these issues. So thank you all for being here. Well done.